Ms. Mayor, will you please read the title of Bill 160844?
An ordinance repealing an ordinance approved the 11th day of January AD 1950, declaring the intention of the City of Philadelphia to organize and authorizing the organization of a parking authority under the Act of June 5th, 1947, PL 458, as amended by Act Number 276, approved May 9th, 1949. Repealing Ordinance 1633, approved the 8th day of April, AD 1983, by which the City of Philadelphia delegated to the Philadelphia Parking Authority certain powers relating to the administration, supervision, and enforcement of on-street parking regulations and collections on behalf of the City of Philadelphia of fines and penalties imposed in connection with the violation of parking regulations pursuant to authority granted it by Section 345 of the Parking Authority Law, and amending Title I of the Philadelphia Code entitled General Provisions, Title IX of the Philadelphia Code entitled Regulation of Businesses, Trades, and Professions, Title X of the Philadelphia Code entitled Regulation of Individual Conduct and Activity, and Title 12 of the Philadelphia Code entitled Traffic Code, to implement the repealer in all places where the Philadelphia Parking Authority appears, all under certain terms and conditions.
Thank you. Before I recognize Councilman O, I just wanted to put on the record that we have first an opinion from the Law Department, which obviously I'm not going to read the whole thing, but I think to summarize, raises legal concerns about, I think it's fair to say, the majority of the bill. Also, we have a letter from the Philadelphia Parking Authority, Joseph Ashdale, Chairman, where basically he references that opinion and saying, for that reason, the authority will not offer testimony before the committee today. He further states, we will continue to cooperate with your office and anyone in city government to help make our city a better place, work and raise our families, and he looks forward to working together in the future. There's also short written testimony from the Managing Director's Office of Transportation and Infrastructure, again, referencing that legal memo that I referred to, saying that for that reason they are unable to offer support for the bill. Also, I want to recognize that there is a representative from the Auditor General's office here, just sort of monitoring what how the bill proceeds today. Before again I recognize Councilman O, who wanted to actually testify on this? We got two. Okay. All right. Fine. Councilman, you want to? Councilman O.
Thank you very much, Mr. Chairman. I introduced a bill which has to do with returning local control to the City of Philadelphia regarding a very critical municipal function, that is administering and enforcing on-street parking and related functions. And that includes the revenues that are generated by these functions for the City of Philadelphia and for the School District of Philadelphia. This would not only benefit the city and reduce tax burdens on citizens, but it is also a protected provision under the Constitution of Pennsylvania that the General Assembly not interfere with the functions of the city. There is a legal memorandum that has been distributed. Many people have received it. That is in dispute by myself, which I'll be presenting on at a later point in time, I guess shortly after we hear from our two witnesses. I would like to state that contrary to the legal memorandum, I'm not trying to dismantle the parking authority. The parking authority is a state authority. I couldn't do that if I tried. The parking authority is properly, its members are appointed by the governor. The issue is that it is interfering unconstitutionally with the city, and that is protected. There are two ways to deal with this if this bill passes. The first is that, of course, the Streets Department or other departments would retain the ability to manage on-street parking for the benefit of the city. The other is simply that we will be able to negotiate an agreement with the parking authority that is more transparent and beneficial to the citizens of Philadelphia. We have not been able to do that because of various legislation and other things. However, I would like to point out, as we will proceed later, that the law is such that the city is constitutionally protected in its ability to govern its own business. Thank you.
Okay, thank you, Councilman. Why don't the two gentlemen come up together? And Mr. Huntington, we have your written testimony, so if you just wanted to summarize that. So why don't you go first? Identify yourself for the record and proceed.
Good morning. Thank you for the opportunity to testify. I'm Steve Huntington. I'm chair of the Crosstown Coalition. That's a federation of 24 RCOs representing communities in Greater Center City, from Fishtown in the north through Packer Park in the south, from Society Hill in the east to Spruce Hill and Garden Court in West Philadelphia, as well as some outlying communities such as East Falls, Overbrook Farms, and Central Roxborough. We were contacted by Councilman O's office, and in response to that contact, and I've been away, so I sent out rather tardily a February 21st memorandum to our 24 members asking whether we should present testimony this morning as to whether an exploration process should commence about returning the parking function to the city. We had a robust response. The request was 6 days ago. 2/3 of our members, 16 members, responded. One of the groups couldn't convene their board, so they had to abstain. But there was agreement of the other 15 members that we should consider taking the functions of parking enforcement and sending them back to the city. Having said that, a number of our members noted that we must be careful to replace as well as repeal, to use the terms of the Affordable Care Act dispute. And a number of the members noted that the bill was short on follow-through. Another comment that sort of bubbled forth was that this would be a major change in how the city operates, so that we were hopeful that perhaps this bill could gain some support with some input from other council members representing other districts. This morning, for the first time, Councilman Greenlee, I saw for the first time this memorandum prepared by the Law Department on January 25th. Obviously, the Crosstown doesn't have the legal resources to opine on the legality of this bill. Speaking personally, having practiced law for 40 years, I'm not surprised to see an opinion like this. Having said that, I think the presentation of the bill did occasion a dialogue among our members, and it produced a pretty quick consensus that the people in the Crosstown neighborhoods support the idea of taking a look at returning parking functions back to the city. So thanks for your time this morning.
Okay, thank you, sir. Let's hear from the other gentleman, and if there's any questions.
Sure, great.
Please identify yourself.
Yeah, my name's Jake Leifer. I'm the co-chair of the Fifth Square, a volunteer-based political action committee dedicated to improving the built environment of Philadelphia. We believe that through this legislation, as well as looking at the operations and technology, that we can help to transform the lived experience for residents and visitors. To this end, we've been disappointed with the current state of on-street parking management, which is an ad hoc process lacking planning and foresight. Many parking districts have on-street parking permits that exceed the capacity of actual on-street spaces. Blocked sidewalks and crosswalks are the norm in our city, violating ADA standards and putting all residents at risk, but particularly children, the elderly, and residents with disabilities. The PPA currently operates with an invitation to enforce parking laws, leaving vast stretches of the city with little enforcement. The focus has resulted in an oversized focus on expired parking meters rather than illegal parking enforcement. We found in the data that there's currently 15 expired meter tickets written for every one ticket regarding blocked sidewalks, crosswalks, or ADA ramps. And as a South Philly resident, I'm acutely aware that the lack of this isn't because everyone's following parking law. We were also disappointed with Friday's PPA board meeting where board members stated that they have no way to improve the number of wheelchair-accessible vehicles, that they are bound by Commonwealth legislation. The current state of 30 wheelchair-accessible vehicles citywide is not where we need to be. If the PPA can't provide the necessary service due to state legislation, perhaps it's time to evaluate the legislative oversight. Fiscal management has been opaque and troubling. The promise to provide funding to our schools has seemingly vanished through vast capital expenditures, creative accounting, and lackluster management of budget creep. Lastly, PPA's revenue initiative to expand revenue through billboards on neighborhood lots without resident input is troubling. We believe the following actions should be taken by the PPA. Immediately implement incentives and initiatives to increase the number of wheelchair-accessible vehicles. Enforce parking regulations throughout the city, particularly those that impact accessibility. Implement demand-based pricing on parking meters to encourage better parking management. And to council, I believe that you have the following capabilities that you could enact immediately. One would be to remove the on-street parking tax exemption so that parking revenue can flow directly to our schools and city. I'd recommend rapidly implementing daylight intersections to ensure that crosswalks are safe and accessible. Implement a well and defined planned residential parking process to ensure that residents who need on-street parking the most have it. And to require RCO approval prior to any municipal billboard being permitted in our neighborhoods, and removing any barriers to enforcing parking regulations that may prioritize relationships or political reasons over resident accessibility. Thank you.
Thank you. First of all, before I ask any questions, no one else here to testify on this bill? Okay. Any questions? No? Okay. Thank you both very much. Councilman, you want to make a statement? Councilman O?
Yes, thank you very much. Unfortunately for the public, this issue seems to stem mostly on a legal interpretation, and law is so very confusing and boring. I have tried to lay out with slides an explanation of the law in contradiction to the legal memorandum that was circulated and for which this city has basically proceeded for the last probably 12 years, if not longer. But that has become the state of the law. And so if you'll bear with me, I'd like to go through what I think is the accurate state of the law. Slide 1. The bill that I introduced is lawful and returns control of administering on-street parking system and other functions to the citizens of Philadelphia, as we just heard. Right now, they don't have that kind of input, and that is unique to Philadelphia. The bill does not dissolve the Philadelphia Parking Authority, and to be clear, I'm introducing an amended bill just to take that language out, because it doesn't matter if it's in or out, it's a state-created entity, and we cannot dissolve the Parking Authority, but there may be some confusion, so I'm introducing an amended bill that removes that language, an amendment to the bill. Thank you, Mr. Chairman. The bill provides Philadelphians the opportunity to take back control of this critical municipal function. Second slide. The city does have the legal authority. The city has the legal authority to take back the functions of administering on-street parking system from the parking authority. The administration's reliance through this legal memorandum on the Pennsylvania court decision, City of Philadelphia versus Schweiker, decided in 2004, and other various statutes afterwards by the General Assembly is misplaced. Next slide. The Pennsylvania Constitution, Article 3, Section 32, prohibits the General Assembly from enacting local laws or special legislation regulating the affairs of counties and cities. By the way, this section was never argued by the city in any of its cases. The City of Philadelphia versus Schweiker stated, the Supreme Court stated, that the city abandoned its claims under Article 3, Section 32, and therefore they were not considered. Next slide. The Pennsylvania Constitution, in its current state, was established in 1874. The delegates to the convention in 1873 were motivated by reform. 10 years prior to that convention, corruption and favoritism in the General Assembly was rampant. Over 90% of the bills passed in that legislature were special and local. Reforms specifically addressed the General Assembly's interference in the affairs of municipalities. Distrust of the legislature is a hallmark of Pennsylvania's Constitution. Article 3 contains express procedural and substantive limitations on the General Assembly's powers. This contradicts the idea in the legal memorandum that the city is a creature of the General Assembly and therefore subject to what the General Assembly does. That's not true. Local control, the ability, are we on the next slide? I'm sorry. That should say Article 3, Section 32? Yes. Local control, the ability of counties and municipalities to make their own decisions is very important in Pennsylvania. To protect local control, the Pennsylvania Constitution, under Article 3, Section 32, prohibits the General Assembly from passing any local or special laws that regulate the affairs of counties, cities, and other political subdivisions. The General Assembly would violate the Pennsylvania Constitution if it legislated that the Philadelphia Parking Authority performed the city's functions and prevented Philadelphia from altering its relationship with the Parking Authority without the Parking Authority's consent, absent a bona fide state interest. Next slide. Act 22 of 2001. The Pennsylvania Constitution requires that the General Assembly enact general laws, not local or special laws, and that they serve the public interest. In 2001, the Pennsylvania Speaker of the House met with the Mayor of Philadelphia. The Mayor ignored him. The result was the introduction of Act 22 that passed, and Act 22 made the governor the person who appointed the board members of the Philadelphia Parking Authority, taking that power away from the mayor. Next slide. As a result, the leadership of the Philadelphia Parking Authority changed and no longer responded to the Mayor of Philadelphia. Act 22 also required the Philadelphia Parking Authority to transfer up to $45 million of its retained earnings to the Philadelphia School District on an annual basis. There was no city parking issue or problem that precipitated this change. Next slide. Consistent with the newly enacted amendments, the governor appointed 6 new members, 2 from the Speaker, 2 from this Senate President pro tempore, 2 from the governor, to the existing 5 board member appointed by the mayor, basically giving the governor and the Republicans in Harrisburg a majority on the parking authority. The city files in common pleas court challenging the validity of the amendments. The city also sought injunctive relief to prevent the new members from being sworn in. Because the city failed to name the governor, the common pleas court lacked jurisdiction and transferred the case to the Commonwealth Court. The Commonwealth Court lacked jurisdiction and dismissed the case. Next slide. The city of Philadelphia then sought an emergency stay and exercise of King's Bench powers with the Pennsylvania Supreme Court. King's Bench is basically falling on the mercy of the court for justice. The Pennsylvania Supreme Court denied the city's request for relief regarding seating the newly constituted board, but stayed further implementation of the challenged amendments. Then it returned the matter to the Commonwealth Court and lifted its stay. So now the Commonwealth Court has jurisdiction. Next slide. The city files an amends it complaint, and files before the Commonwealth Court making the following allegations. It states that the General Assembly's amendments impermissibly and unconstitutionally infringe on the city's home rule charter and corresponding ordinances. It says the amendments violate the legislative pledge not to alter or limit any rights of PPA until all bonds have been fully bent and discharged. The city relied on this pledge in dealing with the PPA. It also stated that singling out the PPA basically is special legislation without substantial, valid, or rational basis. Next, it says that special or local amendments were passed without constitutionally required published notice. Then it claims that the amendments unconstitutionally delegate municipal functions to a special commission. And finally, that the amendments were passed in a bill which violated Pennsylvania's Constitution's single subject rule. Basically, the bill dealt with the city and the parking authority, and all these claims were dismissed for a number of reasons that were explained by the court. Next slide. In response to the city's amended complaint, the Commonwealth and the Philadelphia Parking Authority filed preliminary objections. A full panel of the Commonwealth Court granted their preliminary objections and dismissed the city's complaint. The city then files to the Pennsylvania Supreme Court. Next slide. The Pennsylvania Supreme Court affirms the order of the Commonwealth Court dismissing the city's case. The Pennsylvania Supreme Court found that the city did raise constitutional challenges, including Article 3, Section 32, against Act 22 in its amended complaint, but failed to state these issues in its list of questions presented on appeal, did not discuss them in the body of its brief, and did not include them in its prayer for relief. Therefore, the city abandoned these claims. Next slide. City of Philadelphia versus Schweiker is not on point, and it forms the basis of the Law Department's legal memo. The legal memorandum provided by the Law Department to City Council regarding the legal authority of Bill 160844 that we are hearing today relies heavily on City of Philadelphia versus Schweiker, where the Pennsylvania Supreme Court affirmed the Commonwealth's dismissal of the city's case. In Schweiker, the Pennsylvania Supreme Court found and specifically stated that the city had abandoned its claims under Article 3, Section 32. As a result, the Pennsylvania Supreme Court never considered the issue of constitutionally prohibited legislation by the General Assembly which interfered with Philadelphia's county and city functions. Next slide. Since the decision in City of Philadelphia versus Schweiker, the General Assembly has enacted various laws regarding on-street parking and other municipal functions, empowering the Philadelphia Parking Authority and possibly restricting the City of Philadelphia. The city has not challenged the constitutionality of these laws under Article 3, Section 32. The Philadelphia Parking Authority is not accountable to the City of Philadelphia. It has a direct relationship with the General Assembly. Through the General Assembly, the Philadelphia Parking Authority has obtained additional duties within our city that generates funds which are not known to city officials. These funds are collected by PPA and placed in non-city accounts and used outside the City of Philadelphia. That's to our detriment. Next slide. Act 9 of 2004. Act 9 extended the Philadelphia Parking Authority's administration of cities on-street parking for an additional 10 years after the 1994 agreement between the city and the parking authority expired. So the City of Philadelphia had an agreement with the parking authority, and legislatively, the General Assembly extended it till 2004 without the city's consent. Annual transfers from the Philadelphia Parking Authority to the city would be $25 million of net on-street parking revenue and the excess to Philadelphia School District. So Act 9 changed the formula. Instead of up to $45 million per year going to the school district, $25 million would go to the city if there was any money left over, and beyond that, anything above 25 would go to the school district. By the way, this provision expired on March 31st, 2014. The Law Department memorandum advises that the city cannot release its agreement with PPA without PPA's consent, the Philadelphia Parking Authority. The relevant language that they point to is in the statute, quote, "The authority and the city," meaning the parking authority, "by mutual consent may modify the system of on-street parking regulation to the extent permitted by law." Next slide. In response to Act 9, the city filed a complaint, City of Philadelphia versus Rendell, in the Commonwealth Court, and that was decided in 2005, which challenged the new statutory amendment as, once again, interfering with the city's home rule charter, or home rule powers. The Commonwealth Court sustained the preliminary objections and dismissed the city's case. It stated that these issues had already been decided by the Supreme Court in City of Philadelphia versus Schweiker. Next slide. Footnote 23. However, footnote 23, Judge Levitt for the majority stated, Act 9 extended that contract. Act 9 did not divest the City Council of the ability to legislate on the subject of on-street parking that does not involve proprietary aspects of on-street parking. The dissent reads Act 9 to give the authority a legislative veto, relying on the language that, quote, the authority and the city by mutual consent may modify the system of on-street parking regulation to the extent permitted by applicable law, end quote. The Parking Authority law makes it clear that on-street parking regulation involves acts of administration, supervision, and enforcement, not legislative acts. In any case, the authority has not attempted to veto an act of City Council. The mere possibility of that event does not give rise to a cause of action. Stated otherwise, the claim is not ripe for our review because it is not presented here. Next slide. July 2012 statute. This is the current statute that is now in question. It provides that from March 31st, 2014, when Act 9's provision extending the 1994 agreement between the city and the Parking Authority expires, that the Parking Authority shall enforce and administer all on-street parking regulation in Philadelphia, i.e. indefinitely. This statute did not extend an agreement. It simply legislated what will happen, and that is probably in violation of Article 330, Section 32. Unlike Act 9, the July 2012 statute does not extend the cooperation agreement. The General Assembly simply legislated the city function to the Philadelphia Parking Authority. July 2012 statute does not prohibit unilateral action by city regarding on-street parking and other functions. So nowhere in this statute does it say the city cannot take unilateral action, and such a prohibition would be unconstitutional absent a state interest. Next slide. In City of Philadelphia versus Schweiker, which started its path in 2001 and ended in 2004, the Philadelphia Parking Authority and the Commonwealth claimed that the state's interest in enacting Act 22, which took control of the Philadelphia Parking Authority from the city, was to provide adequate funds to the school district of Philadelphia. In 2001, the state also took control of Philadelphia's financially challenged school district. Since 2001, the Philadelphia Parking Authority has grown significantly and dramatically increased its revenues. However, its costs have also grown dramatically, and additional revenue generation authorized by the General Assembly is not provided to the city or the school district. In fact, the Philadelphia Parking Authority has never come close to giving the maximum of $45 million annually to this Philadelphia School District as provided in Act 22. That would be $675 million over 15 years. Next slide. Money promised to the school district has not been delivered. City Council held hearings regarding PPA's failure to provide funds to the Philadelphia School District. Public officials have expressed the opinion that the Philadelphia Parking Authority appears to provide as little funds as possible to the Philadelphia School District. The state has not funded the Philadelphia School District adequately. As a result, the city has raised property taxes 4 years in a row, increased the school's percentage of use and occupancy tax, and implemented a state-authorized cigarette tax, none of which provides the money that is needed. Today, the state-controlled Philadelphia School District is far worse off than it was in 2001, with even greater fiscal problems ahead and no expectation that the state will adequately fund it. Next slide. Article 3, Section 32 prohibits the General Assembly from enacting local or special laws. The July 2012 statute would be unconstitutional if it prohibits the City of Philadelphia from regulating its on-street parking and related functions. The articulated state interest in providing adequate funds to the Philadelphia School District has not happened, and there's no indication that it will. Bill 160844 lawfully returns cities' on-street parking functions and all related revenues to the City of Philadelphia as required by the Pennsylvania Constitution in Article 3, Section 32. What I would like to state is that during this entire time since the takeover of the Parking Authority and all the other acts that were done by the General Legislature of Pennsylvania, General Assembly, the City Council of Philadelphia has never introduced a bill, and therefore there has never been the opportunity for the Parking Authority or the state to prohibit it, which would give us a cause of action, and I believe, and wind up with a ruling that such a prohibition would be in violation of the Pennsylvania Constitution, Article 3, Section 32. The courts have hinted to the City of Philadelphia that continually raising home rule charter issues, special commission issues, and all the other issues that were outlined in this legal memorandum is already decided by the Supreme Court, and that Article 3, Section 32 has not been raised. I would like to say that we should, in this committee, vote to favorably vote this bill out of committee, and that way we will be able to begin this process in motion. As was testified, we then have some choices to consider, which is nowhere near today. The first thing is we can renegotiate or actually negotiate an agreement between the city and the Philadelphia Parking Authority, because today there is no agreement. The legislature simply directed the city by state law to have the parking authority run its on-street parking function. I would say that's clearly a violation of the Constitution. If there is a hook that the Commonwealth, the General Assembly, or the Parking Authority can hang its hat on, it is that they have done so to adequately fund our schools. I think historically speaking, that has been proven not to be the case, in addition to which passing laws that create new powers within the City of Philadelphia to generate revenues that go to accounts outside of the City of Philadelphia or the school district is counter to the articulated state interest of funding schools. With that, I would certainly answer any questions that my colleagues may have. Thank you.
Thank you, Councilman. Comments, questions, Councilman Green?
Thank you, Chairman Greenlee. I want to thank Councilman O for the PowerPoint presentation. In addition, thank you for all the legal work you've put in and putting together this information. I want to know, can I get CLE credit for this hour?
Yeah, for this hour, yes.
Just
Ethics credit too.
Just substantive credit, not ethics. But I guess one of my concerns, and I'm someone has been a member of the law department as a deputy city solicitor. I've had many challenges and debates with the law department regarding their opinions on various issues. I did have a chance to read the opinion that was provided, solicitor's opinion that was provided. I did have some questions regarding that opinion. However, the city solicitor is the chief legal officer for both the executive branch and the legislative branch. I do believe we need some type of Marbury versus Madison decision. I've been saying that for a very long time. We've had a couple situations in my experience working in city council where we almost came to that situation. I believe Councilman Greenlee can relate to his former boss, Councilman David Cohen, and Mayor Street during the condo trash litigation that almost got us to that point. However, I would like to hear some perspective from the law department before I be able to vote on this bill. I am definitely concerned with a number of activities that have happened at the Commonwealth level, especially more recently regarding both the wage equity bill and the sick pay legislation, which are also pieces of legislation that Councilman Greenlee sponsored was able to get passed. And then also just reflecting on the commentary provided by Cost Down Coalition and the fact that concern about what is the steps for some type of going forward if there was a elimination or a restriction from working with the Philadelphia Parking Authority. My understanding is that the legislation or concept that we would have the police department, streets, and L&I all be responsible for park enforcement in the city of Philadelphia. And I just also have some perspective that how would those departments do that? And I would also like to hear from them as well regarding this legislation. So that's some of my concerns. I am open to amending the bill, but at this point I'm not ready to vote on it because I have those questions outstanding.
Yes, may I respond to that, Mr. Chairman?
If I could just put on the record, Councilman Heenan, Majority Leader is also present. Yes, Councilman O.
Yes. We will not, it will not benefit us to spend time thinking about what is the best way to administer on-street parking, whether it is by having the parking authority do it, maybe do it more transparently, maybe do it in a way more responsive to our planning and citizens' needs, or whether we should have the streets department if we don't pass the bill, because basically there's no reason for us to consider any of this. If we pass the bill, it doesn't mean, out of committee, it doesn't mean that this bill, even if it is passed out of our council, makes any direct changes. It simply means that we have taken an action, and we can take our time and plan on when, if ever, we want to approach the parking authority and the Commonwealth about how we should do this. But it does return a level of power back to the city that is currently absent. If we were to do this, we could do it over a period of time, 3 years, 5 years, or not at all. We could simply have the parking authority continue what they're doing. The only caveat is if the parking authority and the Commonwealth were to take us to court if we pass this bill out of City Council and made it an ordinance. Then they may file an injunction or may file something against us, but that's I think, a matter that is in their hands. I think that, as you raised, overreaching by the General Assembly into the details of what we do. For example, the current bill in the General Assembly would say that I, as a city councilman or any city employee, cannot contact the Immigration Service. That is part of the bill. So, for example, if any of my constituents came to me and said, my family is stuck in Bermuda and we can't get them back over here, I can't call the Immigration Service under that bill. I don't think that's constitutional, and I think it's important to clarify all our duties around the principle that exists in the Pennsylvania Constitution that local people direct their local governments and that is protected.
Okay, thank you. Councilman, I saw you, Councilwoman Gim's already, and if I could go to her first, and if you wanted to come back. Councilwoman Gim?
Yes, thank you, Mr. Chair. My one comment would be that I believe that the parking authority should be here. I feel like any entity, whether or not they agree with the substance or the claim that is made before them, should show up before City Council as an act of respect for the council's relationship, that they should be present to answer any questions that we may have, that the sponsor of the bill is one of 6 members of City Council who are here today, and that there are 5 other members who are also interested in potentially asking questions. But I really did not feel that it was appropriate for the parking authority simply to opt out of something that they did not feel like they particularly wanted to be part of. And I hope that we can send a clear message to the parking authority that, especially with the new leadership that is in place, that we would like to see a more collaborative opportunity to talk, and especially probably when we disagree. And if there is a disagreement in place, I would hope that the parking authority would be able to come into City Council chambers and be able to directly address that disagreement, and we can end it where we end it. But it is a problem when a major entity and partner with the City Council chooses to opt out of a hearing in which they're the subject of it. So that's my first comment. My second comment is, I also want to commend Councilman O for his tremendous work and his research on this. There isn't anybody else, I don't think, who has been as laser focused on these issues, and I share many of the frustrations that led to the the formation of the bill. Certainly, I think there are a lot of questions about the role of the school district funding. In particular, we've raised questions about the fact that, for example, in 2014, the Parking Authority came before City Council requesting increases in parking rates, promising that we would reach what should be $18 million a year. We are maybe projected to reach that, maybe projected to reach $8 million a year by the $8 million for FY 2017 by the time that their fiscal year ends, but that's even up in the air. That's a difference of $10 million a year. I don't think that that's acceptable. I don't think it's acceptable for the Parking Authority not to have had a performance and management audit prior to this in order for us to better understand the expenses that they accumulate and accrue. But we do have new leadership at the Parking Authority. We also have a full performance management audit that will come before us, hopefully from the Auditor General, Eugene D. Pascal, and I believe that the Attorney General is also very clear and aware of the Parking Authority's responsibility, not so much as its own entity, but as an institution of the public trust. And it should be seen as that kind of institution, that it is a public trust, much like the Hershey School, much like other kinds of entities. It has a responsibility to the City of Philadelphia, to the school children of Philadelphia, and to the airport, which is a massive regional center, and is also some area that we should be asking a lot of questions about. But I don't know that I'm prepared to vote on this bill at this time, in particular because I think that there are the outstanding questions that have been raised both by the Law Department and by my other colleague here that are outstanding. But I do think that that shouldn't dissuade us from being even more diligent and vigilant about our duty to continue to ask questions and to make sure that the Parking Authority knows that we expect answers.
Thank you. Councilman Green?
Yes, thank you, Chairman Greenlee. I concur with a lot of the comments that Councilwoman Ginn made. For me, and the focus of my vote is primarily on the fact of the City of Philadelphia versus Schweiker case. I think Councilman O has raised some points in reference to the Law Department's opinion. Primarily, it seems like the crux of the case and his opinion with my short review of his information regarding Article 3, Section 32. And some of the issues that he raised are legitimate in reference to why the city may have abandoned various claims in the past litigation regarding this issue. But from my perspective, before I'm able to take a vote on an issue, as an attorney, I need to make sure that I have a full understanding of all of the issues, and also really want to hear from the Law Department and really challenge them on some of the issues that Councilman O raised in this issue, and hear their response to some of those concerns.
Thank you. All right, here's where we like to go, unless there's other comments. Councilman O has an amendment, which I think everybody kind of, from what I understand, agrees that could be moved out of committee. We're going to go briefly into the committee meeting so that he can move that amendment. I'm then going to ask that we move it back into to the committee hearing and hold it to the call of the chair. So we will temporarily go into the committee of the Law and Government Committee's meeting, and the chair recognizes Councilman O.
Thank you very much, Mr. Chairman. I move to amend Bill 160844. A copy of the amendment has been circulated.
Second.
It's been moved and seconded. All in favor?
Aye.
Opposed? Hearing none, the amendment is adopted. And we will now move back into our public hearing. And Bill number 160844, as amended, will be held to the call of the chair. Thank you.